the League of Women Voters of Washington County. This is part of the League of Women Voters of Arkansas State Convention, which makes it even more of an honor to have you all here for the Landlord-Tenant Rights and Responsibilities panel. We are very pleased that we have a member of the League of Women Voters to lead the panel, and that is Professor Rob Lefflar. He is a legacy to the League. Both his mother and father were members of the League of Women Voters. So this is a very big honor. Rob is the Ben J. Altheimer Professor of Legal Advocacy and a professor at the University of Arkansas for Medical Sciences. He teaches in several different fields, which include torts, health law, and related fields. He also is a professor in Japan and teaches in Japanese in Japan and at the law school here, which is named in honor of his father. We are so pleased that Rob has helped us pull this together today, because when we realized that our community and our state needed to have a conversation about the laws that impact people who are landlords and people who are tenants, we realized how ignorant we really were. So today is a great educational effort, and we thank our panelists for helping with this, and we thank you, Rob, for your leadership in pulling this together today. So with no further ado, I turn this over to Professor Rob Lefflar.
Thank you very much, Mary Alice. It really is an honor and a privilege to be able to be the moderator of this panel today. As you all know, the topic is a very important one. It's one which our two panelists here are really experts in, and so this is going to be, as Mary Alice said, a wonderful educational experience, I think, for all of us. Our first speaker is Professor Lynn Foster, who is Arkansas Bar Foundation Professor of Law at the Bowens School of Law at UALR. She's really an authority on Arkansas real estate as well as probate and trust law. She publishes in both of those areas. She's the editor of the Arkansas Real Estate Review, the Arkansas Probate and Trust Review, and she is also one of Arkansas's 4 uniform law commissioners. And that's an experience where she's engaging with lawyers at the very top level of the profession from all over the country in the proposal of uniform laws and the presentation of them to the Arkansas Bar Association and the legislature. She was recently elected to be an academic fellow of the American College of Trust and Estate Council, which is pretty high up national organization, and she's the recipient of Faculty Excellence Awards for service, the first Law School Outstanding Service Award, the Arkansas Bar Association CLE and Presidential Excellence Award. I could go on. It's a real pleasure to have you here.
Thank you. This is working, right? Yeah. Okay. All right. Well, I agonized over how to trim portions of this presentation because there were going to be 4 of us here today, but now there are only 2 of us, so I can proceed through it a little bit more slowly, and perhaps that will be a good thing. So thank you, Professor Lefflar, and thank you all for inviting me here today. It's an honor to be here. I have taught property law here in Arkansas for about 15 years now. And right now I'm on the Uniform Law Commission's committee to revise the Uniform Residential Landlord and Tenant Act. And I've served on that committee now for about 4 years. And also I have the honor and the privilege of being appointed to the Arkansas Non-Legislative Commission on the Study of Landlord-Tenant Law in 2012, along with Howard here. And we worked together on that commission for a year, at the end of which time we published our report, and it's available on the internet if you're interested in looking at it. I've spent time reading the eviction statutes of all the states and the implied warranty of habitability statutes of all the states. And so I have spent a lot of time working with this area of law. What I'm going to focus on today is two areas of the law. And before I do that, I'd just like to make a general remark, and that is that landlord-tenant law, like a few other areas of law, for example, debtor-creditor law, rests on a balance of rights and obligations. And if the law gets out of balance, it's not good for society. We saw what happened with debtor-creditor law in 2008 with the mortgage meltdown. We saw some of the abuses of the mortgage servicers that were inflicted on innocent people in trouble with their mortgages, and there have been several steps taken to correct those abuses. On the other hand, if the rights are too much in favor of debtors, then creditors become unwilling to lend because they feel like they're not going to get what's owed them. So there's, just as in debtor-creditor law, there needs to be a balance. In landlord-tenant law, there needs to be a balance as well, for somewhat of the same reasons. And on the Landlord-Tenant Study Commission, we determined that Arkansas law is significantly different from that of all other states, every single other state, in two important areas. And those are the areas of eviction. We're the only state to have a criminal eviction statute, and implied warranty of habitability. We're the only state to not have an implied warranty of habitability. And so what I'm going to talk about today is I'm going to explain what the law is here in Arkansas, contrast it with the law in other states, and talk about some recent developments in Arkansas in these areas. Without that introduction out of the way, first of all states, including Arkansas, have civil eviction statutes. And in a civil eviction statute, you have a landlord suing a tenant. Our eviction statute here in Arkansas is called unlawful detainer. And the landlord sues the tenant. Let's assume that the landlord wins. And at the end of that time, if the tenant hasn't already left the premises, the tenant is ordered to leave the premises. And if the tenant doesn't leave, then the state acts and enforces that judicial decision, and a writ of possession is issued to the sheriff or other similar official, and they physically remove the tenant from the property. We are, however, the only state with a failure to vacate statute, as you can see there on the PowerPoint. And I should also add at this point that in a few states, a very few states, landlords are allowed to use self-help. What is self-help? Well, probably the most common method is the landlord changes the locks. And this is done without going to court or filing any kind of an action against the tenant. The landlord just changes the locks. Another that I've heard about from people is removing the doors, or turning off the heat in the middle of the winter if the landlord is supplying the heat. Those are all methods of self-help. And most states make them illegal. I shouldn't even say most, virtually all. Self-help is illegal in Arkansas as well, under the case of Gorman v. Ratliff, which was decided several decades ago. So one of the issues that the Landlord-Tenant Study Commission spent its time on was listening to the complaints of landlords and those who represented landlords on our commission about our unlawful detainer statute, our civil statute. They were not happy with it. I think Howard is going to talk to you a little bit about that, and so will I in a few minutes. But the issue that the Commission spent its most time on, of all the things we considered during the year, was trying to craft a better civil eviction statute for landlords. So that's part of the history here. And when the Commission finished its work, I became very interested in the failure to vacate statute, and I decided that I wanted to do some research on it because I had heard different things about it, and I wanted to find out how true they were. So some of the things that I researched were, pushed the wrong button there, I had heard that not all courts would even hear failure to vacate charges, and that turned out to be true. About a third of the courts in Arkansas refused to hear the charges. Either the prosecutor refuses or the judge. I heard that even though the statute calls for typical dispositions, that these weren't being followed by the judges, and that's true in many cases. There's a lot of non-uniform enforcement. I heard that there are a lot of, the term would be mom and pop landlords, I hope that's not offensive, but these would be landlords who aren't giant landlords with many, many, many holdings, but people who own maybe an extra house that they happen to be renting out. But these were the folks using the statute. I had heard that most of the defendants under the statute were women. And so I spent some months researching the statute and wrote an article about it. So, what is the statute and how does it work, basically? I've given you the citation in case you want to go look it up. It's not very long. It was originally enacted in 1901, and interestingly, if you go back and read the article that the newspaper at the time printed about it, you'll see the same arguments raised against it as are being raised today. Nonetheless, it was enacted by one vote in the Senate. And unfortunately, in 2001, the penalties under the statute worsened, and it became quite a bit more unconstitutional. So, in 2012, there were over 2,000 cases in Arkansas that were filed for failure to vacate. And so how exactly does the statute work? Well, first of all, the statute says that a tenant who doesn't pay rent when it is due forfeits the right to occupy the premises. So if you if you're paying rent of $1,000 a month and it's due on the 1st, and you don't pay on the 1st for whatever reason, you're in the hospital, you're out of town, and somebody was supposed to pay for you and they didn't, you immediately fall under the statute, and you forfeited your right to occupy the premises. Then, if the landlord gives a notice after 10 days, if you're still on the premises, the landlord can then go to the prosecutor and file an affidavit with the prosecutor that you have violated the failure to vacate statute. And notice the conviction, the statute says on conviction, the tenant can be filed $25 a day that she fails to vacate. Now that's all the old statute, that's the pre-2001 statute. Subsection C then goes on to say that a tenant who pleads not guilty and remains on the premises must pay the court the rent the landlord says is due. So let's say that you're a tenant and maybe your landlord had not made a repair, and after a couple of months of haggling over this, your landlord told you that you could go ahead and make that repair and deduct it from your rent. So you make the repair, you deduct it from your rent, and now the landlord comes back and says, oh no, I didn't say that in writing, I didn't say that at all, and you owe me the rent. And the landlord tells the court the rent is due. There's no investigation by prosecutors of these cases, by and large. There certainly isn't in the counties where lots of these cases are handled. So at this point, you come into court and you plead not guilty, and sat in court for a day and watched tenants, and I've heard a lot about this from people who represent these tenants and from judges who deal with these cases. And a lot of tenants come into court and they think they're going to get their day in court. And they bring all these papers in because this is going to court and they're going to get to tell their story. And the judge will ask two questions. One, have you paid your rent? And if the answer is no. Two, are you still on the premises? And if the answer is yes, then typically they're ordered to leave. And that's it. No one gets to tell their story in most courts. And again, enforcement of this is non-uniform, so it does vary around the state. But notice that if you come into court and you plead not guilty, under this statute, the statute requires, must pay the court the rent that the landlord says is due. Is there any investigation of what is due? No. Typically, the landlord's word is just taken as being correct and true. Think whether there's any other criminal charge where if you plead not guilty, meaning that you should get a trial, you have to pay money into the court. It doesn't, there's a problem there. So, the statute goes on to say that if the tenant is found guilty, then the landlord gets the rent. It goes on to say, if the tenant is not found guilty, then the tenant gets the rent back, of course. That happens occasionally under the statute, not that often. But then, this is the real catch-22 of the statute. You were only supposed to pay this amount into the court if you pled not guilty. But then the next subsection says that if you plead guilty, or if you plead nolo contendere, or if you are found guilty after a trial of refusal to vacate, and if you have not paid the rental payment by then, now you're guilty of a Class B misdemeanor. So, if you pled guilty, there was no requirement that you paid the rent into court. But now the statute says if you plead guilty and haven't paid the rent, you're guilty of Class B misdemeanor. So it's a strangely worded statute. It contradicts itself. A statute like this is hard for judges to enforce. What does it mean if you're guilty of a Class B misdemeanor? You can be fined up to $1,000 and you can be jailed up to 90 days. So, as I worked on my article and I talked to people who have experience with this statute, I kind of started to make a list of the problems that are caused by it. One I've already referred to: do prosecutors investigate, or are these landlord allegations simply taken as true? Another problem is with subsidized housing, either public housing authority or Section 8 landlords, landlords who rent to tenants who get vouchers from the federal government because of poverty, and so they're able to pay their rent because of assistance from the federal government. Housing and Urban Development forbade, a long time ago, decades ago, forbade such landlords, either public housing authority landlords or Section 8 landlords, forbade them from using the failure to vacate statute, because in HUD's opinion, it didn't afford tenants due process. And this was before 2001, when the statute was changed. But as I discovered in doing my research, at least one public housing authority in Jonesboro was using the failure to vacate procedure, and I looked at the Little Rock affidavits in Pulaski County, in the Little Rock Criminal Court. They screen for Section 8 landlords, and they make the landlord certify that the landlord is not a Section 8 landlord. But there are other affidavits in other courts that don't ask anything about Section 8, which leads me to believe that this is not a question that is asked. And so I believe that there are some Section 8 landlords who use this statute as well. A tenant who pleads not guilty must, as we already mentioned, pay this amount of rent that is alleged that is due. You could call this perhaps a bond, but if you think about criminal actions and criminal procedure, a court determines how much bond is to be paid, not the victim. And here, the landlord is determining the amount that is to be paid to the court. The amount of bond is discretionary with the court. Here, it's not discretionary. The statute is clear that this amount must be paid, and it must be this amount. And I've already mentioned the problem with paying in order to plead not guilty and paying to ask for a trial. Another minor problem, compared with these problems, is the problem that district courts have no registry. The statute requires that these payments be made into the registry of the court. But district courts have no registry. They don't have much of a mechanism for taking money like this. And we've already talked about the catch-22 aspect of the statute, so I won't go over that again. Where that part of the statute came from, the part about paying, it comes from civil statutes where if the tenant wants to remain on the premises while an eviction action is going through, the tenant can pay money into the court, and it's held by the court, and the tenant gets to remain on the premises. But it got lifted out of the civil statutes and stuck in the criminal statute, and thereby renders the criminal statute unconstitutional. Can we consider the landlord to be a victim, and is this payment restitution to the victim? Again, the statute sets out the exact amount that must be paid to the landlord, and it is determined by the landlord, although presumably if there is a trial, the court could determine that a different amount was due. But if we look at the restitution statutes in our criminal code, we see that restitution, again, is discretionary with the court, it's not mandatory, it's a factual question that's decided by a preponderance of the evidence, and defendants may be allowed to pay in installments, which typically does not happen in these FTV cases. So the effect of this statute, basically, the statute has one kind of an overriding aim, and that is to get the tenant off the premises by whatever means necessary. And by and large, it succeeds in doing that. Few tenants challenge it. And, I'll say right now that most tenants that have the statute filed against them are probably not paying their rent and should no longer be on the premises. But those tenants who have a legitimate dispute, a good faith dispute with the landlord, don't have any rights under this statute at all. The statute gives the judge no power to evict tenants, and the Attorney General, in fact, issued an opinion to this effect a few years back, and yet, across the state of Arkansas, judges routinely do this. It's one example of how poorly the statute is written. The enforcement is uniform. There are approximately 233 district courts in Arkansas, and my survey found that some courts fine tenants a flat fee. Some courts, many courts, don't fine at all if the tenant leaves when ordered. Even though the statute mandates the collection of rent, most courts don't collect rent. 29% of all district courts refuse to hear FTV cases. 18 counties out of our 75 counties refuse to hear FTV cases. So I thought those were kind of interesting findings. Another problem with the statute is that our Constitution says that no person shall be imprisoned for debt in any civil action on mean or final process unless in cases of fraud. And so there's an argument here that what we're really doing is imprisoning tenants for failure to pay their rent, which is a debt. So, a little update on this statute, and that is that I think it was January 20th. I need to memorize that date. Judge Wright in Pulaski County Circuit Court held the failure to vacate statute unconstitutional on 5 grounds: due process, right to trial, equal protection, imprisonment for debt, and cruel and unusual punishment. And he said that it was unconstitutional both on its face and as applied to the defendant, Smith. A few months later, the Craighead County Circuit Court also held the failure to vacate statute unconstitutional. And I was told that, 2 days ago?
2 days ago, First Circuit.
First Circuit now, Poinsett County, has also held it to be unconstitutional. So there is some attention being paid to this statute, and it seems to be the opinion of most judges so far, I think, who have heard these cases, at least in the very, very recent past, that the statute is unconstitutional. In the 2015 legislative session, a bill was introduced that would have repealed the entire statute. That bill did not make it out of committee. Another bill was introduced that would have rolled back the 2001 changes that made the law even more unconstitutional. I would argue that even as it existed before 2001, it was unconstitutional, but of course that decision, a couple of courts would disagree with me on that constitutionality was litigated a couple of times before 2001, and both times it passed muster, although I don't think either time it was squarely on those issues. It was more like dictum by the court. Anyhow, 904 also failed to get out of committee. So, Who uses this procedure? Who is affected by this procedure? I had access to all affidavits filed by landlords in the Little Rock Criminal Court in 2012, and so I went through and counted. And of all of the tenants, 62% of them were black women, and 71% of them were women. And I had just been told by some students of mine over the years who have worked in the prosecutor's office that this statute did mostly affect women. And I discovered that to be true when I actually looked at those affidavits. I was also fortunate enough to obtain affidavits from the Springdale court that hears these cases. And in Springdale, not as striking, but still 57% of all defendants were women. Another byproduct of making eviction criminal rather than civil are the consequences of not appearing or not being able to pay a fine. If you don't show up in civil court, then a default judgment is entered against you. If it's a civil eviction, then the writ of possession will issue, and the sheriff will come out and evict you if you're still on the premises. But if you don't show up in criminal court, then a bench warrant is issued. And when you're picked up, and you almost always are going to be picked up sooner or later, you will be arrested and jailed. So if you can't pay a civil fine, again, we don't have debtor's prison in the United States, not since the 19th century. But if you don't pay a criminal fine, you can be jailed for that. So there are very different consequences because our statute is a criminal statute. I looked a little bit at the landlords who were filing these lawsuits in Little Rock, and I noticed that landlords who own multiple units regularly file. I had the addresses of where either the landlord or the rental property was located, and I would look that up on the internet, and sometimes I would find big ads on the internet for such and such big apartment complex. The apartment complex where my son lived at the time used this statute. One LLC filed 16 failure to vacates in 1 year. You may hear landlords arguing that they just don't have the money to hire an attorney, but I would submit that if you're a landlord who's filing 16 failure to vacates in 1 year, now those are just the tenants that you have to get rid of. You're going to have a lot more tenants than that, and maybe as part of your business model, you should factor in hiring an attorney to do civil evictions for you. Yeah. Well, more opportunities for our law school graduates. Landlords do evictions for us. A common pattern of behavior, and I heard about this from many different people, and I actually saw an example of this one day when I was sitting in the clerk's office doing my research, was the landlord doesn't make repairs, and in Arkansas, and I'll come to this in a minute or two, there's no implied duty for a landlord to make repairs unless the landlord promises that in the lease. So something falls into disrepair, the landlord doesn't repair it, the tenant tires of complaining, and then either stops paying the rent, which although there's no right to do that under traditional